it appears you have done. Obviously, in that instance, you are required to pay the legal fees in respect of that legal representative yourselves, you and or your family. In the event that you are unable to pay the fees of private legal representation, you have the right to approach legal aid to assist you in that regard. Should you make such an application, and should such application succeed, a legal aid representative will then be appointed for you, in which event no monies are required to be paid by you. Your third option is to represent yourselves. The court deems this the most undesirable option because even were you to be trained in the law, it is undesirable for an accused person to represent themselves where they are an accused in a matter. Bearing in mind also, your matter you have been indicted in the High Court, which means it's a serious matter with serious consequences. Do you all understand your rights? Mr. Kekana, Mr. Mabusela, Mr. Matlala, Miss Matlala, and Miss Nzama. Thank you. Thank you. What arrangements have been made then, Miss LaRue, regarding the docket? The accused may be seated.
Yes. My Lord, I already did discovery in, I think, August last year to all of the accused. And then the matter was then centralized. Certain charges were centralized, and then the matter was eventually transferred, I think, on the 11th of November for this date.
If I can just then confirm with counsel for the defence that they are all in receipt of the docket content.
I have to add something.
Oh,
yes.
Sorry.
So, in the meantime, another legal team has come on record for accused 3 and 4, who obviously have not received discovery yet. So we were engaging with each other since about 2 weeks ago, which was the 15 January. And they were then provided with the dockets in this matter. I've since then also received a request from accused 3 and 4's legal team that they also want downloads of all the electronic devices in the state's possession. I must say at the outset that that material does not form part of my case docket, but be that as it may, the state is generous and we will give it to them. So I was provided with a hard drive yesterday, and that download is in fact running as we speak. It's about 1 terabyte of information. The other legal teams were also invited and say if they want that, they must just provide me with a device, and the download will be done for them also.
Okay, and that is in respect of? What information is that?
That is downloads made from the cell phones of accused 3 and 4. So it doesn't really relate to the other accused, but if they want it, they can have it.
So for all intents and purposes, the court understands then, apart from this information, that the docket then has been provided to the defence.
That's correct, my Lord. There's one docket that Mr. Groevier says he hasn't received. It's a Sunnyside docket. That's not really the subject matter of the charge sheet, but I will provide that also in case it becomes relevant. It's a 2-page docket. It consists of an A1 and an A2. So that will be provided to him still today. So that is the position.
Yes. If I can just then inquire from Mr. Hadebe, do you confirm that?
My Lord, I do confirm that discovery was given to us. Yes. However, there seems to be housekeeping issues and some outstanding documents which form part of the contents of the docket which we haven't received, but we have endeavored to submit a drive to the state so we can get our standing.
Yes.
standing
You will
contract.
liaise with the state
liaise with the
in
state.
that regard. Thank you.
Yes,
Mr. Riviere, save for what Council mentioned about the two-page.
I confirm what has been placed on record by Advocate Leroux. There is also a further ballistic report which we have been advised will be forwarded to us in the foreseeable future. So the necessary arrangements has been made
Thank
for
you.
the state to provide the outstanding documentation.
Ms. van den Heever.
May it please the court, my lord. My lord, the issue is as follows. My learned friend is correct if she indicates to the court that the attorney of record is a new attorney of record. He came on record in December, and I unfortunately, the court must bear with me a little bit. I just need to give the court a bit of history. Subsequent to him coming on record, and I think having one consultation, our client, Mr. Matlala, accused number 3, was whisked away in the middle of the night to Kokstad, which is quite far away in KZN. That started causing severe issues with consultation, and I'll get to that in due course. He eventually got disclosure from the state. Us having gone through the disclosure, we noticed that there's quite a number of documents, I don't want to use the word outstanding, but we've got loose documents in some of the dockets that has no sense of purpose. There's no cover affidavit, for instance, to explain where these documents come from. Having perused, for instance, the allegations that was contained in the bail application, we came to the realization that there were seizure of certain electronic devices and downloads made. None of that information is contained in the docket. And with the greatest of respect to my learned friend, it's not what the state intends to use. We entitled to evidentiary material in possession of the state that can be exculpatory to our client or that can assist him in defending his case. So for that reason, we did officially ask for that. But that's not the end of it, my lord. As I said, having gone through it, it's clear that there's pockets, there's lacunas in their disclosure.
Yes.
So we need to deal with those issues, also having regard to now the issue of the electronic devices that's being disclosed to us. More importantly is the fact that when you get disclosure, what only would happen is you'll take your documents and sit with your clients and go through it and get instructions. We've not been able to do that. As we've indicated to your lordship, the issue is that the client is sitting quite far away, and there's been severe issues with that. So for now, because I'm going to address the court on that issue a bit later, safe to say, yes, we got disclosure. 2, we asked for additional disclosure. 3, we're still going to ask for more disclosure. It's clear that there's issues in the docket.
Yes. So you will liaise with the state with regard to those issues.
However, and this is the caveat that we want to, our client, for various reasons, wishes to have a speedy trial in this matter as quickly as possible. And for that reason, this disclosure and the speedy trial needs to happen as quickly as possible. So we're going to come to that. I don't know if my learned friend wishes to further address the court on other issues. I would then ask, with leave of the court, address the court on a number of issues pertaining to the issue of preparation, again, going back to the docket, going back to the disclosure. But for now, as I said, if your lordship has taken note of our issues with the disclosure, I will then address the court on the other issues in due course.
Yes.
May I please?
Thank you. And Mr. Tansi.
Thank you, my lord. We are in receipt of the story. Thank you.
Yes, thank you. Before I ask Ms. van den Heever then to address me on the other issues, is there anything you wish to add?
Indeed, my lord, I have provided your registrar with a copy of a media statement that was made available to me on the 30th of December this year. and then that was the first wind that I got of the whereabouts of accused number 3. Mr. Maluleke, who's the brief 4 advocate van der Heever, reached out to me around the same time 2 weeks ago, indicating that the same concerns that's raised now by Advocate van der Heever, they can't consult, and the problems around that.
So is accused number 3 still being held at Kokstad?
Ibongweni Correctional Facility, which is in Kokstad. That is correct, so my lord. This media statement is all that I have in writing at this stage on paper. I have engaged with the investigating team. They say it was not on their request that the accused was moved. It's not on my request that he was moved. It is purely, as it is contained in this media statement, a prerogative of correctional services. They feel that there are security concerns. I can't take that further. I obviously don't have enough information to say, yes, I agree that he should be held here closer, or I don't agree. I simply cannot respond meaningfully because I have not been able to engage in detail with the Department of Correctional Services. So that is as far as I can take it. Thank you.
Yes. Thank you, Ms. van der Heever.
Maybe to give your lordship a little bit of background, in Mbongweni Correctional Services Centre, DCS proudly explains it to be the only super maximum facility where inmates are placed in segregated cells for 23 hours a day, and they're only given 1 hour of exercise per day. That is the background to this. To get to this particular correctional services facility, you have to take a flight down to Durban. My attorney, I think a week ago, managed, and there was all kinds of issues pertaining to that, and I will address the court to that. But let me just give the court the factual situation. If you fly down to Durban, you then need to rent a car and then travel, and it's my attorney 3.5 hours from Durban to get to Mbongweni to consult. It then takes approximately an hour, depending on the situation, there's sometimes more, to actually get to your client. Then, to consult, he sits behind a thick glass where you can barely hear each other, with people around you listening to what's going on. And I respectfully submit it's a well-known fact that they also record whatever consultations or conversation goes on there. And I think one of my colleagues that's here, one of my little friends, can confirm that situation. So you, at the end of the day, your access to your client to prepare for anything, whether it's trial-related, pre-trial related, is literally down to an hour, maybe 2 hours. What's happened to us after numerous attempts being blocked by DCS from seeing the client, alleging that he's got different lawyers, finally acceding to the fact that this is his instructing attorney, an appointment was given for us to go down. In the middle of the night, literally, on the Saturday preceding the Monday's consultation, notice was given by the area commissioner that nobody's allowed to see him, and the only person that can deal with it is the commissioner itself. Now, I respectfully submit, anybody try and get hold of the commissioner in this country, it's almost a case of impossibility. From my own experience, I can place on record to send emails to the ministry, send emails to the commissioner. Just don't get responses from them. At the end of the day, my attorney, because he previously engaged with the head of Imogweni, got word, no, it's okay, you can now come through. And I've explained to the court the mission it was to get to me. Where we are right now, my lord, is I've indicated to the court that we wish this matter to proceed as quickly as possible. There's numerous issues playing out or scenarios playing out in the background. And all of that we respectfully submit is causing our client and will cause him not to get a fair trial at all. And in order to alleviate some of those issues, I've been instructed that once we sorted out the pre-trial issues is to urge the court to give us a preference date in this matter for hearing. But before we can even get there, we need to consult with the client.
Yes, if I can just stop you there. Obviously, this court is not the role planner and is not...
I'm not even going to ask the court to deal with it. That is
Yes.
not, I fully understand
Or
that. I just,
this court cannot allocate this matter to
we
me.
fully understand, but I want the court to understand
Yes.
where we're coming from.
Yes.
That we wish to exercise those rights, and the court has that in the back of its head. So the issue now is that we need to consult with our client. If our client is again taken back to Kokstad, we are then sitting in a position where we will be effectively barred from doing proper consultation. My learned friend has indicated to the court there's 3 dockets that's been disclosed to the defense. If the court will just the new data that we will be given today is a terabyte. And I think the court can imagine how many hours it will take just to go through that. So the situation is that we wish the client to be detained at any facility that makes him accessible for the defense, for us to prepare for this pre-trial and get proper instructions. Now the Correctional Services Act, as much as they in this press release say that in terms of Section 6, the Commissioner is legally empowered to detain an offender or at any correctional facility, that must be weighed up against his constitutional rights at the end of the day. And this court has the right to as an inherent jurisdiction, to deal with any issues that infringes the client's constitutional rights to get a fair trial and to properly prepare for his case. I spoke to my learned friend, and I'm indebted to her for hearing us out. She seemingly has no issue with the fact that we postponed this matter for 2 weeks, that we have access to the client, in other words, if we detained somewhere near, whether it's in Pretoria or Johannesburg, for us to consult and come back to this court and deal with the pre-trial issues that's normally being dealt with. She has indicated to the court that this is all she's got. Now, I would respectfully submit, my lord, and I have a case, and it's a very difficult situation I know that she finds herself in, because of course she can't interfere with this, but this honourable court, by way of its inherent jurisdiction, I respectfully submit, can make an order that that our client be detained at a facility where we've got access to him, where we are not restrained in the manner that we get access to him, and we respectfully submit that would entail a facility that's near to this court for purposes of the postponement. I am going to ask my learned friend, she is the person at the end of the day that would be able to speak to her investigating team, because all of these things, I mean, we've all been in the business for long enough to know everything is linked to each other. It's not, somebody doesn't sit there, the commissioner doesn't sit in isolation and make decisions and nobody else knows about it. So if there's some way, even if we stand the matter down at this point in time for an hour or so, to see if we can come to some kind of action in this matter. If we can't, we will have no alternative but to ask the court to stand the matter down, perhaps till tomorrow, for us to launch an urgent application and get an order that effect be given to our rights under the Constitution. Because, as I say, if we can't come to an agreement, that's the only way out that's left to us. And there
Yes,
is
but
indeed case law on the fact that a court that this of the correctional services.
Yes.
It's a relative old case, but it's a precedent for this court to follow
Yes.
and say, yes, for you to prepare and do whatever is necessary to your client's rights, I can make an order that correctional services does A, B, and C.
Yes, but this court dealing with the pre-trial, I would propose that should the matter not be capable of resolution, that, or the issue, that you do launch an urgent application then. Because obviously, from what you have explained, the situation is untenable. How are you supposed to take instruction, and why should you be put to the inconvenience that you are and that you allegedly have been put to in order to consult with your client? This, I don't even want to go to this allegation of recording of consultations, which is horrendous and horrific and appears to be incredible. However, yes, I think, or I wish to propose that possibly counsel liaise, that an explanation be given as to why your client cannot be held. To the best of my knowledge, yes, I've also heard that Kokstad prison or Ebongweni correctional facility is supposed to be the safest correctional facility in the country. However, according to my knowledge, most of the correctional facilities in the vicinity of Johannesburg, and there are a number, have all got maximum security sections. So I don't understand why this is the case. But having said that, possibly there are reasons correctional services may furnish as to why he ought to be detained there. But it appears to be prejudicial and not in the interests of justice that you are inconvenienced to this extent.
So maybe just two more issues to raise. On the
Yes,
25th of January, my attorney...
I'm not done
Oh,
yet.
sorry,
Sorry. So I would propose that in that respect, that counsel liaise, that counsel for the state attempts to obtain whatever information she can from correctional services and from the commissioner as to why this accused cannot be transferred to a local facility, and should that fail, that you do then launch an application to the urgent court.
Indeed, my lord. If I could just, my attorney just made me aware of two facts. On the 15th of January, they did in fact write a letter to the DCS, to the commissioner himself. He's failed to answer it at all, as I've indicated to the court. It seems to be a pattern of conduct. And the second thing is, he's been informed by the head of Mbongweni that whatever consultations we need to do, we have to ask permission of the commissioner to do that, which is another big issue. So if the court then can be so inclined, if we can stand down and see what we can sort out here, we would be thankful.
Yes.
I don't think my learned friends have an objection.
Bearing in mind that I am at 11 with an special motion to take a long time.
resolution.
Absolutely.
Your registrar what the position is.
Okay. I'm thinking what you can and postpone for days and seeing what resolutions hopefully you are able to basically deal with. And I can understand your frustration personally. This court had, the client will remain nameless in its practice, had to deal with a high-profile figure, and notwithstanding having personally arranged the consultation with the head of the prison, I had to wait 2 hours in the parking lot before I could go in and see the client. The court understands security issues. The court understands all of these issues, but these obstacles are extremely tiresome and prejudicial to counsel, and the court sympathises with you for what you experienced.
Look, I think your Lordship's suggestion is a good suggestion. If my learned friend is so inclined, maybe we can then postpone the matter till next week, Wednesday. I think it gives us a few days, if my learned friends are available on that day, to try and sort the matter out in the interim.
Yes. Are your colleagues required, because it doesn't affect them, surely this issue of the transfer or the possible transfer of accused number 3 to a local facility?
I don't know, they have to speak for themselves, but maybe we could also give them some opportunity to look at the disclosures, get disclosure of the various items that they've also asked now, and we can at that stage reassess the situation as to a specific date for the pre-trial. That's just a suggestion from my part.
Yes. I think it's a good suggestion. Ms. Leroux, the court doesn't want to put you under pressure because the court understands what pressure is. But are you relatively flexible in respect of this matter to deal with queries or emails from defence counsel, arrange for the furnishing of what allegedly you need to furnish or what has not been furnished, etc.?
Yes, my lord, I am indeed. There's just a matter that we're going to court on Wednesday,
Yes.
which is sort of related to this matter because it involves some of the same accused and some of the same counsel. So Wednesday may be difficult.
Is Wednesday not too soon for you to obtain?
So Thursday would be good. Thank you.
What is the date on Thursday?
That would be the 5th of February, my lord.
But look, I've got a problem with the 5th.
Yes. What about Friday?
Next week Friday.
Next week Friday.
It's
Friday.
oh, I've got the dates wrong. Yes, you're right.
So
It's not-
I would suggest then
So Wednesday would be
my lord.
then Wednesday would be fine. Wednesday would be fine. Wednesday would be fine, my lord. I had my wires crossed. It's actually that other matter is Thursday, the 5th. So Wednesday, the 4th
But
is fine.
to give you additional time, would the 6th not be? Would you not be available on the 6th? Because it would also suit the court.
I am available on the 6th, my lord.
Miss
But look,
van den
I'm
Heever,
quite happy with
firstly
the
you,
6th.
because you are the main counsel involved in this
I'm
issue.
quite happy with the 6th. I've got
Okay.
no objection to the
Would
6th.
the other counsel, with regard to...
My lord, no, sorry. I'm sorry. I mean, this court on the
With
6th,
me?
with your lordship.
In which matter?
Is that with the Mdluli matter? That other pre-trial matter?
Oh no, yes, but remember, pre-trial takes a few minutes, generally.
Yeah. But I
this-
also made a note here that the Swichland matter is then for judgment on the 6th.
No. I think you're mistaken there.
Do I have my wires
Yeah,
crossed?
that was postponed, I think, to
Oh,
the
no.
end of February.
Yes, you're right. Yes, my lord. So no, then the 6th would be suitable because it's just for a pre-trial in the Mbulu matter.
Yes. Is it a
100%.
first appearance or not? I don't think it's a
No,
first
it's
appearance.
been several.
Yes. So it will be quick.
Yes.
Mr.
With
Riviere.
respect, I'm not available on the 6th. I'm available either 4th or the 5th or the following month.
Okay.
My lord, we are available on the 6th of February, but however, we are also available on the 4th of February.
Okay.
If you are to accommodate Mr. President.
Yes, it's just that the 4th is on Wednesday. We already on, it's Thursday already.
How's the 5th, ma'am?
The Commissioner is not going to give you an answer in a day or two.
How's the 5th, ma'am?
Is the 5th?
I'm not available.
Yes. Look, Council, these issues in respect of the pre-trial in the matter, it was just Ms. van den Heever, your suggestion was a good suggestion in the sense that should there have been other issues, they could have been clarified on that day. It's not necessary for council. It's not going to be a pre-trial. However, council who are available, other council who are available and who may have issues with in regard to documentation that they still require or that has not been disclosed or anything of that nature, you are welcome to be in this court so that we can simultaneously deal with those issues. But it's not going to be essential for you to be here in the sense that the pre-trial is going to be dealt with. These are basically pre-trial issues. Okay, so can we agree then on, what did I say, the 6th?
The 6th. Either the 6th.
Yes. Yes, tell me the accused. Accused number 1, is he in custody or not?
Yes.
And accused 2,
2 in custody, 3 in custody, 4 and 5 on bail.
4 and 5 on bail.
That's correct, my lord.
On this particular matter, maybe I must just correct it. Accused number 1 and 2 are not in custody on this particular case. They're on warning in this case, according to what I've been informed.
That's correct, my lord, they're in custody on another matter.
Okay. 1 and 2.
Yes.
Give me a moment. And accused number 3
He's in custody.
in this matter. Yes. Anybody else wants to say before I postpone the matter? Yes. Thank you. Thank you. The accused can stand. Hello? Yes. Your matter then is accordingly postponed to next week, Friday, which is the 6th of February 2026. Accused 1, 2 and 3, you will remain in custody. Accused 4 and 5, your bail is extended and you are warned to appear on that date. Counsel for accused number 3 and counsel for the state are to liaise with one another and investigate and speak to whoever with regard to an attempt to have accused number 3 transferred to a correctional facility within the court's jurisdiction. And obviously, in the event that that proves unsuccessful, the court should be advised as to why. The other counsel in the other matters, those who are available and who have issues pertaining to disclosure, are welcome to attend court on the postponement date in order to deal with such issues. On that date, and when the matter is then postponed further, Mr. Crouvier, you are kindly requested to have your phone, if possible, available in order to agree to the postponement date. I'm talking about the postponement date subsequent to next Friday.
I will see to it. Thank you, my lord.
Thank you.
If I may, my lord,
Yes.
I'm just thinking here that the court says that a counsel may, who are not affected, may only come on that day, but then matter will be postponed to another time.
Yes. In other words, what I'm trying to say is that should you have an issue relating to discovery, for example, you have an issue that you are not able to sort out telephonically or verbally or by email with counsel for the state, and you wish to bring it to the court's attention, you are welcome to appear and bring that to the court's attention.
My lord, but I'm talking about something different.
Yes.
It is about then on Wednesday or on Friday, the matter will then be postponed to a date
Yes.
when I probably will not have on that day on Friday say I'm not available.
Yes.
It will be postponed to a date. I don't know whether convenience to me.
Yes, but that is why you will leave your phone on, as will Mr. Crouvier. Those counsel who will not be here next Friday will leave their phones on in order that a suitable date to everybody can be communicated to all counsel. Are we all at Idem?
As the court pleases, may I suggest that you ought to adjourn for a bit because it might be a bit of chaos now.
Well, I'm going to adjourn to reconstitute the court because I have a special motion, an urgent special motion at 11:30. Well, as soon as possible. Thank you, counsel. Thank you to the court staff. The court adjourns.
Okay.
So hy is nie van die manne met wie jy moet vriend.
Is hulle maar is nie nou in hegtenis nie.
Nee, hulle het nog nie gaan aanmeld nie.